All right, everybody, we're going to get started here in literally 30 to 60 seconds. We're going to wait and let Matt get prepped and ready to go with his slides. Well, while we're waiting on that, thank you for attending the webinar first and foremost. Special thanks to Matt from TC Engine joining us on the call today. He's bringing a lot of ITAR expertise onto this call or onto this presentation, so really thankful for him. Today's talk specifically is really important because IT security and compliance is now moving from previously just being guidelines to now being requirements that are showing up in contracts, etc., to now enforcement. So we're seeing fines roll out, we're seeing more enforcement from a awarding standpoint, and all of that gets a little hairy. And so some of these types of talks are very important as to cover some of that territory. And how to kind of mitigate risk, and also to get competitive advantage for being proactive on some of these pieces and having strategy and plans behind it. So just to get to a couple housekeeping items, please use the question function as I mentioned previously for those of you that have just joined. As we go along, ask questions, and hopefully some of our speakers will be able to respond to those via just texting back, or we may answer them live on the discussion. Also, too, there's going to be a Q&A session at the end, so hopefully any questions that aren't hit up during the webinar, we'll be able to address those at the very end. Also, too, all of your questions and all of your polls, please send those in. Poll responses will be anonymous. The webinar is also being recorded and will be distributed within minutes after the end of the webinar. Check your spam or your junk folders in the event that you don't see anything within 30 minutes or so. But like I said, you should see something within a couple minutes. So without further ado, let me go ahead and do some quick intros to the speakers today. So first and foremost, Scott Edwards of Summit 7 is a national expert and speaker on NIST 800-171 DFARS and FAR compliance, as well as ITAR compliance. And Scott's technical experience was honed at NASA as chief engineer for the NASA data center. And Scott also served as an officer in the U.S. Army Signal Corps after graduating from West Point, and in addition has a Master's of Information Security from James Madison. Currently, Scott is the president and managing partner of Summit 7 Systems. And then, as I mentioned previously, thank you, Matt, for joining us. Matt Henson is an export compliance modernization specialist and has nearly 10 years of in-depth experience helping companies comply with IT requirements mandated by ITAR consent agreements. He also has a master's in international studies and international trade and development from Oklahoma State University. So without further ado, Matt, if you are prepped and ready to go, I'm going to hand it over to you. Let's get talking.
Absolutely. Thank you so much, Sean, for that introduction, and thanks to everyone for joining today. Just a quick plug, follow us on LinkedIn. If you haven't already, we post a lot of good content out there, as well as updates about seminars and just good educational content on the topic of IT export compliance. All right, so let's talk about what we're going to cover today. We've got an action-packed agenda, so we're going to jump right into it. We're going to start with a little bit of regulatory overview, just to set the context for what is a consent agreement. Then we'll do an introduction to consent agreement, so kind of a high-level overview of what's typically in a consent agreement, fines, penalties associated with those. And then we'll look at FLIR, and then we'll review the proposed charging letter that came out with the consent agreement. We'll review the FLIR consent agreement, and then we'll open up for Q&A. So let's jump into the regulatory overview. So the regulating authorities from an export compliance perspective basically are responsible for overseeing the implementation of the ITAR and EAR. We'll take a look at that here in a second. But essentially, export compliance boils down to the execution of business transactions in accordance with the laws and regulations governing exports. So what are those? We have Congress that has established the laws. So the Export Administration Act, which has subsequently been implemented by the IEEPA, and then the Arms Export Control Act. So Congress established the laws, and then they empower the president to enforce those. The president, in turn, empowers the Department of Commerce and the Department of State to enforce each one of those laws through the regulations. Within the Department of State and within the Department of Commerce, you have the Directorate of Defense Trade Controls on the state side, and then the Bureau of Industry and Security on the commerce side. ITAR, which ultimately define the control list. So on the commerce side, you've got the commerce control list, which defines what is controlled and how it's controlled. And you have the same thing on the ITAR side, looking at the United States munitions list. So on the commercial side or the commerce side, you've got the commercial dual use items. So those items are primarily commercial, but could have some type of application from a military perspective. And then you have the items that are specially designed for military application. And so this is essentially how the regulating authorities break down for the ITAR and EAR. And of course, today's presentation, we're going to be focusing on the ITAR side. So what is ITAR Compliance? Well, the State Department has recently updated the website. It's a fantastic website, lots of great information out there. And this is what they say about ITAR Compliance. So ITAR violations can be harmful to the national security and foreign policy of the U.S. and may result in civil penalties, criminal penalties, and other costs, including loss of reputation and revocation or rejection of export licenses. So to ensure compliance with the ITAR, DDTC strongly encourages registered exporters, manufacturers, brokers, and others engaged in defense trade to maintain compliance programs that assist in the monitoring and control of exports and other regulated activities. Strongly encourage, it's good use of words there, because when you get in trouble, the Department of State or DDTC strongly encourages you to comply through a consent agreement. So what is a consent agreement? Again, straight from the Department of State website. A consent agreement is an agreement that includes monetary penalty and or enforceable conditions such as review, audit, and reporting requirements, compliance program improvements, debarment if applicable, appointment of a special compliance official, or what they call a designated official or DO in the FLIR consent agreement, and monitoring by DDTC. And the consent agreements last typically 3 to 4 years. From a penalties perspective, when you're dealing on the civil side directly with the Department of State under a consent agreement, violations are up to $1 million per violation. If you look at the FLIR consent agreement, they had 347 alleged violations in the proposed charging letter. They got off for 30 million. So, less than 10% of what they could have been charged. So the penalties can be absolutely devastating. The other stick that the Department of State has is debarment. So basically the revocation of export privileges, including revocation of all current licenses and the denial of licenses for the term of the debarment. And as it says here, these are generally settled and negotiated through consent agreements, although there have been some agreements come out recently that are less onerous than consent agreements, and you can find those on the Department of State's website. When you move into the criminal piece for violating the Arms Export Control Act, this is where the Department of Justice gets involved. This is where potential imprisonment comes into play, and you'll see there the fines and the debarment also apply. So the anatomy of a consent agreement. Modern penalty and oversight agreements typically include 3 documents: a proposed charging letter. This is the what went wrong. It's a description of the alleged charges and violations. There's a consent agreement. This is the thou shalt mandates from the Department of State that include things like commitment to compliance, applicability to mergers, acquisitions, and divestitures, remedial measures, the appointment of a designated official, if applicable, audit requirements, and whether or not the respondent has been debarred, and other legalese. The order is a summary of the PCL and the consent agreement. And upon execution, the consent agreement is effective, and the alleged charges included in the PCL are addressed, so long as the respondent holds up their end of the bargain. So just because you enter in a consent agreement doesn't mean you're free and clear, right? You've got to hold up your end of the bargain, and there are certain folks there that are helping you uphold that end of the bargain, including a designated official and the Department of State itself. So how did consent agreements happen? Well, here we've got the Directorate of Defense Trade Controls, and here we've got a company. And the Directorate of Defense Trade Controls highly encourages companies to submit what are called voluntary self-disclosures. So when a violation is uncovered, the Department of State wants to see that. They want to see it fairly quickly. They want to be able to evaluate whether there are national security or foreign policy impacts. And typically, voluntary self-disclosures are settled without issue. The voluntary self-disclosure includes corrective actions. The company says, hey, we have these issues, but we've implemented these corrective actions. And typically, the Department of State comes back and they close that without further action. You also have what are called directed disclosures. So these are cases where the Department of State themselves uncover a violation and then come back to you and tell you you have to disclose. So this is a bad place to be. You certainly want to voluntarily disclose in pretty much every case because you don't want to get a directed disclosure, right? Because this is an aggravating circumstance in the Department of State's eyes. It's also worth mentioning here, there are mandatory reporting requirements for disclosures involving 126(1) countries. So in those cases, if you had an illegal export with a embargoed country, you're mandated to report that. You're obligated to report it. It's not optional.
Hey, Matt.
Yep.
So can you tell us a little bit about the FLIR consent agreement, and was it a voluntary disclosure or a directed disclosure?
It was both, actually, and we'll look at that here in a minute. How many voluntary disclosures came out? There were definitely directed disclosures, and so we will jump into that here in just a few slides.
Awesome.
So what happens is the violations start to stack up. You start to have multiple repeat violations. You have violations with 126(1) countries and nationalities. You have violations involving significant military equipment. So significant military equipment is basically an item that has some type of unique military capability that warrants additional controls. And when you have a bunch of money that the government's invested in SME, you get MDE, which is major defense equipment. So when you have violations involving SME and MDE, it's certainly a risk multiplier. And then you have willful violations. This is the big no-no. So you know that something is going to violate the export control laws and you do it anyway, or someone does it anyway, or you find out that there is a violation, it's an ongoing violation, and now that you know, you don't do anything to stop it, right? So what happens is these violations start to stack up and that starts to impact your risk. So as soon as you start entering into these types of issues where you're reporting those, you're already out of the green, right? And you're moving into the red. And before long, DDTC starts to perceive systemic gaps in your compliance program. Well, how do you know? You receive a non-standard response from DDTC. So disclosures are going in, you're putting corrective actions in, you're probably having repeat violations, and at some point in time, the Department of State says, okay, hey, wait a minute, guys, you told us you fixed this 2 voluntary disclosures ago, right? Why are we seeing it again? So when you receive this non-standard response, and in general, when writing any type of voluntary disclosure, you want to be extremely accurate and factual in your responses, right? A lot of times, trade compliance engages in corrective action creation as a creative writing exercise. So they're creating these and committing the company to these corrective actions that, you know, certainly may not be optimal, but may not even be feasible, right? So there's definitely some lessons learned here around the whole corrective action management process and how to engage the business, which we'll talk about in future presentations. So how the FLIR consent agreement happened? Well, FLIR submitted 18 voluntary disclosures over a 5-year period. They also had directed disclosures, so things the Department of State uncovered on their own and directed the company to disclose. They had multiple corrective action failures. These included failures to implement corrective actions they committed to, or failures to implement effective corrective actions. They had a repeat discovery and disclosure of violations. So very similar, if not the same violation occurring multiple times across the business. The disclosed activity continued in violation of the ITAR in one instance. So they had one instance of willful violation. They had illegal exports that involved SME. They had illegal exports that involved 126 countries, including Iran, Cuba, Iraq, Lebanon, and Vietnam, of which those last three were basically embargoed countries prior to or when the violations actually occurred. And the issues are not localized. They were not localized to a specific facility, product line, sales territory, or authorization type. So there were systemic gaps that the Department of State perceived. In total, there were 347 alleged ITAR violations resulting from the respondents' inadequate internal controls and commitment to compliance, which resulted in a $30 million penalty. And we'll dissect that in subsequent slides. So in DDTC's words, how did it happen? There was significant compliance program and internal deficiencies that directly contributed to the violations. Deficient ITAR expertise and senior leadership oversight, the failure to effectively investigate and cover and disclose violations, that the frequency and repetitive nature of the same violations, and failure to implement remedial compliance measures, corrective actions represented to the department. From a mitigating factors perspective, the company submitted 18 VSD. So the Department of State looks at that as a positive and takes that into account when crafting the charging letter and the consent agreement. The company entered into an agreement with DDTC, so they signed the consent agreement, and they also instituted a number of self-initiated compliance program improvements during the course of DDTC's review. So if your company is in DDTC's crosshairs, you must stand up a trade compliance improvement program to mitigate consent agreement risk. So if you're getting those non-standard responses, if you're having repeat violations and disclosures, stand up a program very similar to what you do under a consent agreement to go out and address those. You're in a much, much better place. It will cost you 1/3 the amount that it would under a consent agreement. So just a quick point there. So let's look at FLIR. So FLIR positions itself as the world leader in the design, manufacture, and marketing of thermal infrared cameras. They were founded in 1978, and they've had 3 acquisitions, one in 1990, one in 1998, including Sweden, and one in 2003. So they've grown through acquisition, perhaps not as much as some of the other companies that are on the line, but growth through acquisition certainly presents some challenges. They have total revenue of $1.8 billion in 2017. They have more than 3,000 employees. And from an export perspective, an ITAR perspective, they have 3,740 export licenses, authorizing $9.9 billion in exports over the 5 years that the Department of State included in the charging letter.
Hey, Matt.
Yep.
Hey, quick thing. This is a good segue point just to bring something up again. Everybody, if you can, go ahead and check out some of the polls that we put up, because some of that will help drive our conversation a little bit to tie it back to kind of how this translates to the rest of the group. But yeah, you're doing a great job, Matt. All this is really good information.
Great. All right. So, you know, with my experience, I'm going to make some assumptions about FLIR and some of the challenges that they're going to face. So my assumption is they have highly autonomous businesses. So businesses that are pretty much operating independently. When you see companies grow through acquisition, a lot of times they purchase those companies, they leave them alone so that they can remain profitable, right? And there's not a whole lot of integration, into one company. As a byproduct of that, typically they have limited corporate resources, so people and capabilities of the corporate office, and limited corporate governance, so oversight of what's actually happening within the businesses. They typically have disparate IT networks and systems, so multiple different networks, perhaps different networks for each company that they've acquired. Within those networks, duplicative IT systems for email and SharePoint and ERP and PLM, right? All the core business systems that you need to operate. And they also have highly decentralized policies, processes, and controls, which if you read any consent agreement, the Department of State definitely has a bias towards centralization. From a trade compliance perspective, and kind of managing and executing a program, you're viewed as one company under your ITAR registration, regardless of whether or not there are 20 businesses operating independently. And this is why it's so important to have a centralized program, because one of those businesses screws up and it can impact the entire company. So let's look at the FLIR proposed charging letter. Let's jump into the PCL. So this is how DDTC viewed the violations in the proposed charging letter. And if you recall, this is essentially the department's statement of alleged violations. And this is how DDTC categorized those. One category is for foreign person employment. And this typically, or basically involved non-U.S. person access to information. You also have license management, and when we talk about licenses here, just to be clear, we're not talking about software licenses, we're talking about export licenses. So when you go out and get an export license, there are a lot of different things that go into that to maintaining compliance. Getting the export license is easy, right? You have to be able to activate it, use it, record transactions against it, and report those transactions in certain circumstances, which brings us to Part 130. So Part 130 payments, in Part 130 is essentially the requirement to report to the U.S. government fees, commissions, political contributions that relate back to a sale. Highly complicated, highly complex requirement that ties into the Foreign Corrupt Practices Act. And this has kind of been a hot button issue for the Department of State over the last several years, and it's reflected in the last several consent agreements. And it's an area of heightened focus for the Department of State, mostly because companies are struggling to implement Part 130 requirements. They had additional charges, violations resulting from the respondent's inadequate controls and commitment to compliance. So there are some additional things sprinkled in here. From my perspective, this is how I broke it down, the proposed charges. I broke it down in the category of cyber compliance. So I essentially took the foreign person employment and I put it in the context of cyber compliance failures, which are failures in IT systems. So unauthorized location, access, and transfer of technical data within your IT ecosystem. Next is licensing. These are failures in obtaining, using, and maintaining licenses and exemptions. You have shipping, so failures in shipments of items. You have Part 130, which are failures to provide the required reports. You have trade show security, so failure to physically safeguard items at trade shows. And corrective actions, which basically failure to implement corrective actions or effective corrective actions. So this is how the proposed charges break down within this categorization. You'll see there that the vast majority, about 56%, are cyber compliance issues, right? 85 to do with license, you've got 39 with shipping, and so forth. And certainly the licensing piece ties into cyber compliance, so there are definitely some related issues there, which we'll talk through as we drill through the proposed charges. So let's take.
Hey Matt.
Yep.
I got a quick question that rolled in. I think kind of applies, and it's more of a comment kind of thing. But this individual said it seems that companies enter into consent agreements rather than going to court. Is that kind of about right? Is that normal? This whole situation with FLIR?
Yeah, absolutely. If you don't enter into a consent agreement and you play hardball and you try to, push off till the statute of limitations kicks in, you get hit with, say, $100 million fine, like I did back in 2007. So
this slide could look a lot worse.
Yeah, you certainly want to play ball. You certainly want to get the Department of Justice out of it if you can. And ideally, even before you get to the point of entering into a consent agreement, you're going back into the Department of State, expressing your commitment to compliance, implementing enhancements in your IT program, communicating back to the Department of State saying, we know we have issues and this is what we're doing to fix it, committed. So cyber compliance. So I'm going to give a background here because there's a pretty good narrative in the proposed charging letter. So from April 2008 to August 2012, there were 4 voluntary disclosures. And disclosed unauthorized exports of dual national, third country national employees from over 15 countries. So these are employees that, they may be, be a French resident of France, but they may have been born in another country, therefore they may be a dual national, right? You may also have third country nationals, meaning they're not necessarily a resident of the country that they're residing in currently, but they're from Syria, for example, right? So they're a third country national operating in that environment. So they had DNTCNs from over 15 countries, including Iran, Iraq, and Lebanon, of which Iraq and Lebanon at the time were embargo countries. They had violations that occurred at domestic and overseas locations. And in reliance upon the reported corrective actions, DDTC closed it without further action. Now, what we're going to see here is in June 2014, they submitted another voluntary disclosure, which basically stated the full scope of violations was not previously reported. They found 2 additional embargoed countries, 126.1 countries that the company was sharing data with, and individuals from those countries, I should state. They had corrective actions that were not implemented. So evidently in the 2000, one of the 4 previous consent or voluntary disclosures, they committed to confirming the nationalities and terminating unauthorized access, and that did not happen. At one of their locations, they did not collect the dual national, third country national attributes in order to know what violations were occurring, what types of authorizations needed to be in place, and this was at the facility in Sweden. And their IT provisioning process resulted in unauthorized access. So they were basically provisioning folks access to data based on business need only and not taking into account the identity attributes of those individuals, the classification of the data, and determining whether or not there was an authorization in place that would allow that to happen legally. So Scott, I want to pause here really quick and ask you, from an IT perspective, what are you seeing with regards to identity management? Are folks typically, do they have these identity attributes that they need to make informed and accurate, or accurate and timely export control decisions? Are they capturing that? Is that an Active Directory?
It's not an Active Directory by default. So what we're seeing is that customers are trying to add capability to Active Directory by adding different identity attributes into Active Directory, and then fulfilling, putting the information in Active Directory that properly maps. What we do see is some concern from some organizations about putting personally identifiable information in Active Directory about nationality and about citizenship status. And so there are some workarounds for that, specifically like using attributes that might not necessarily say you are a U.S. national or a foreign country national or what have you, but maybe gives a specific code in the directory, and that code may map using the right key to a specific a country or set of countries. And so those are some of the things that we're seeing, but by default, people are not putting nationality and citizenship in Active Directory or in identity management systems in most cases. I would say probably less than 10% of the companies that we deal with have that data already in their directory structure when we get to them.
And it's great point, Scott. Is with GDPR coming online, you've got to be careful with this information, and using some type of maxing or nationality proxy is certainly a way to help mitigate that. All right, so if you're on the phone and you're on the call and you haven't looked at identities and whether or not that information is captured in your IT systems in some ways that you can leverage it to make accurate and timely export control decisions, you've got your first task.
Yeah, based off of the poll we had, it looks like around 40% of the room would rate their ability kind of in the non-confident area on their ability basically to identify non-U.S. persons, whether dual national or TCN.
Okay. Great, and we'll talk to that here in a minute about some of those identity attributes and how they're used. So in June 2014, you had the voluntary disclosure. I'm just going to read here. So IT provisioning access control. So the respondent disclosed that The manner in which it granted employees permission to information technology system resulted in unauthorized access by DDTCNs to ITAR controlled technical data. These foreign person employees had access to technical data at their assigned work site and at the respondents' work sites located in foreign countries. Approximately 1,350 foreign person employees had access to all ITAR controlled technical data over 1,400 files located on the respondents' servers in 22 non-US facilities. Now there's a footnote here that we need to look at. It says, while access does not mean that the employees viewed the information, respondent lacked the IT records that could confirm which employees actually accessed ITAR controlled files. Respondent concluded that the violations occurred at 22 of its non-US facilities, and its department's position that the respondent transferred technical data to foreign person employees that was necessary for the job performance on its servers without authorization. So there's been a big kind of controversy about this, what's known as potential access. So just because someone has potential access to the data doesn't mean that they actually accessed it. Well, key point here is that in areas in your ecosystem where you have mixed users, non-US persons, and ITAR content, you need logging capabilities, right? Because whether you can prove that they had access or disprove that they had access, it's really, you know, it's the same, it's two sides of the same coin, right? You have to have that ability.
Hey, Matt.
Yep.
Here's something applicable. It's kind of an interesting question. So obviously you're familiar with GDPR and the requirements there. So in many cases, having to disclose information, to log it in a specific way, to have consent, all this kind of stuff. How do you reconcile the requirements for something like GDPR with the privacy requirements and then the ITAR piece where you need to log who has access to what, et cetera?
It really comes.
Sorry for the curveball. It was a good question, though.
How much time you got? So, you know, it really comes down to what I call license activation and your ability to activate an authorization and put a non-US person on that authorization, say they're authorized to use it. That should take place in country, right? And that information, the response that you get is you should just know that that person is authorized against the license, right? Which has been vetted and performed, say in Germany, for example, and there's been a record created in German that's located in Germany. That, you know, should you ever need to audit, you can go back and look at those records in Germany. But that information is basically just sent back, and you know that that person's authorized against that license, but you don't necessarily know their citizenship or nationality.
Gotcha.
So Matt, going back to the issue of potential access, one of the big challenges is really making sure that we understand as the IT organization that may be running these IT systems, that we can essentially prove the negative, that an individual did not access, even if they could, they did not access the environment. So if the potential for access existed and the user never accessed it, but we couldn't prove that they never accessed it, then we have to treat that as a access occurring. Is that accurate?
That's typically how the Department of State has looked at it. On the Department of Commerce side, they'll say, oh, well, we do things entirely differently, right? Until you can prove that an export occurred, no export occurred, right? And they try to make that distinction, but again, it's two sides of the same coin. It's the same capability that's required to really meet either use case. That's right.
And so I guess the point I'm trying to drive to is to make sure that everybody understands how critical audit logging and logging in general is within an IT organization when you're dealing with ITAR data. The ability to prove who accessed what, when, where, and how, and the ability to prove that people who should not have access did not and could not access any of that information.
Absolutely, Scott. And you know, this little matrix here on the bottom is really quite helpful, and I should probably explain it here briefly. So there in the kind of bottom left-hand quadrant, you have no ITAR data in US persons. So you have, if you can implement controls that say, hey, no ITAR data can go in here and we can ensure only US persons get access to it, you basically have to have two different controls to get, circumvented in order for a violation to occur. Non-US person gets access, and ITAR data gets inserted. You have the just above that, where you've got the low, moderate risk. You've got US persons who have access to ITAR environment, right? So in that instance, again, ensuring that only US persons get access to the environment, and you prevent non-US persons from getting access. If you can show those logs at a higher level, right, versus like kind of down the weeds transactional system level, you can meet that requirement. Under the mixed users no ITAR content, that low mod in the bottom right hand corner, essentially what you have to be able to do is prevent ITAR access from, or ITAR data from being introduced into that environment, right? So you've got non-US persons in there, and if you can prevent ITAR data from being interjected or injected into that environment, you can address the risk. And your high risk areas, right, is where those areas where you have mixed users and mixed content, you have ITAR content in that environment. And this is where you need your logging and full-blown controls, because you really have to be able to enable authorized access within those environments. Okay, these are the actual charges from a cyber compliance perspective. So the first section here we'll look at is legal export. So they had unauthorized re-exports of technical data in IT systems. They continue to allow unauthorized exports of technical data. And then they allowed 126.1 nationals to access technical data. You also have record keeping failures, so failure to maintain technical data, re-export records on IT systems, so the logging piece. So these are the actual charges from the charging letter. You also have export licensing failures. You have failures in the license application process. So when applying for an authorization, the company misrepresented and or omitted material facts. Kind of as a sub-bullet to that is they failed to disclose the citizenship or permanent residency of their individuals, right? So they didn't have the identity management capability in place to say, hey, who all do we need to try to authorize on this license so that we can get it approved and perform legal exports. And then you have the attempted use of an ineligible party. So the company knowingly submitted a couple of license applications to the Department of State for denied party, which the Department of State rejected, and then hit them here in the consent agreement or proposed charging letter. You have use of the licenses. So once you get the license, that's the easy part. The hard part is complying with it. So you have violations of terms and conditions and provisos that are included in the licenses, as well as violations of exemptions. You also have license maintenance. So they had failure to reflect corporate restructuring. So at one point in time, they spun off a new subsidiary that was not reported to the Department of State, and it was not reflected through amendments in all their licenses. So the company was actually, exports were occurring at this subsidiary, and there was no authorization for those exports to occur. So pretty big issue resulting in systemic failures. You also have, from a shipping perspective, so you have temporary export shipments, so failure to obtain endorsement by customs. So when those temporary exports are going in and out of the United States, customs needs to endorse those transactions. You had failure to implement shipping statements or use the correct shipping statement. So in one case, you had the misidentification of an ITAR item as the EAR. You had failure to properly incorporate the required export control statements in the shipping documentation. And then you had failure to ensure a freight forwarder correctly identified significant military equipment in their EEI filings. So when they file an export with essentially customs, this is information that has to go into that system. We also had just outright illegal exports. So exports to foreign person employees from 126.1 countries, and exports without a license. So one instance where 5 thermal imaging systems were exported without a license. Finally, record keeping, failure to maintain, properly maintain records. Let's move into Part 130. So they had failures in the license application process, so failures to disclose fees and commissions. So when you submit a license to the Department of State, there's certain information that you have to provide in there about your agreement to pay, or if you've offered to pay fees or commissions with respect to the sale. They also had record keeping requirements for failure to maintain those Part 130 records, and then finally reporting failures, so failures to update DDTC concerning the payments and commissions that are required under Part 130.10. You also had a kind of a unique situation in your trade show, so loss or theft. So you had failure to properly safeguard items at trade show, so things that were outside the line of sight of whoever was working the booth and weren't secured. Those items disappeared. You also had one instance where they put it into a cabinet that was locked, but the same key unlocked all exhibitor cabinets, and items were stolen. And finally, corrective actions. So they had failure to stop ongoing violations, and they presented inaccurate information concerning the implementation of the anticipated corrective actions and disclosures involving foreign person employees. So that's essentially how the FLIR charging letter breaks down. I know we're getting about to our 15-minute warning here, so I'm going to buzz through these slides real quick about my assumptions, and we'll take a quick look at the consent agreement and talk through those slides briefly, and we'll jump into questions. So these are my assumptions about FLIR's compliance program. It's a legacy export compliance program designed for yesterday's paradigm, meaning the focus is on physical domain controls, things like physical location controls, technology control plans, signage, etc., about where you can go within a facility. Physical access controls, so foreign person employment, visitor controls, badging, electronic badge readers, etc. And then physical transfer controls, so freight shipments, courier shipments, hand carries overseas when you're traveling. The characteristics of a legacy program, they're paper policy dependent, they're tribal knowledge dependent, users have to be aware of the policies, they're user behavior dependent, they have to act upon their knowledge of those policies, they're typically manually executed, and because of that, they're opaque. All right, manual execution leads to a lack of visibility. So in order to get visibility into a series of transactions that are manual, you basically have to pull the records and do a complete audit just to know what's going on. And that leads to a lack of oversight. They're geared towards physical domain controls, and they're highly decentralized, right? This is essentially the characteristics of a legacy program. In addition, legacy programs generally don't know what their data is, what data is controlled, its value, where it's located, who has access, when it's being transferred, and to whom, or whether or not the location, access, and transfers are compliant. Typically lack visibility into cyber assets and transactions, and they lack cyber compliance capabilities. But this is a legacy approach to export controls, and this is why companies struggle so much with cyber compliance and addressing the challenges of the modern paradigm. So here you have your business cycle, and the way that trade controls have traditionally been implemented is that you classify and control at time of export shipment. So you got a physical commodity that's leaving the facility. Well, that's great, except that you have data exchange with customers and with vendors well before that physical item even exists, right? If your external data exchanges look like this, right, you get some pretty significant risk. But what about the data exchange internally, right, in your own IT ecosystems? If your internal data exchanges look like this, you have significant risk, right? You have to be able to identify where that information, what information is controlled, where it's located in your IT networks, what servers, what applications, and then what users have access to those, right? Those are some of the steps that you have to go through in order to determine what your risk is and begin mitigating it. So word of caution, if the previous slides described your compliance program, your company's at risk of becoming the next FLIR, right? So the FLIR consent agreement. So consent agreement terms, conditions, and requirements are described in this particular case in 27 paragraphs. And we're not going to go through all 27 paragraphs. I'm going to touch on several just to explain what they are. So these are
if everybody's mic was hot, there would be a sigh of relief around the room, I think.
Yeah, we're covering 26. this way. So the first is a penalty. So there's $30 million penalty, 30 million total, 15 to be paid in installments, 15 to be reinvested in remedial measures, with 5 million in credit towards work already performed. $10 million total for 3,000 employees. So you've got just over $3,000 per employee to fix the issues. You've got to be really, really smart about how you go about doing this. And even being smart in the approach, I can guarantee you the company's going to have to spend at least twice this amount, if not 3 to 4 times this amount. That's been my experience in consent agreements. Next, we have parties to the consent agreement. So this basically says, you know, FLIR is the party. Department of State has jurisdiction. Here's a statement saying the respondent is committed to compliance and implementing the remedial measures. And then you have incorporation of consent agreement requirements into new acquisitions and a 60-day notice prior to the sale, structure, merger, or acquisition. So let's just touch on this briefly. So acquisitions, so the consent agreement requirements must be incorporated into any acquisition within 6 months, a pretty tall order. From a merger perspective, the consent agreement requirements apply to any merger, restructuring, or acquisition, so you can't restructure or, you know, your way out of this. There's 60 days prior notice with signed acknowledgement of the purchaser, right? So you can also pull the wool over somebody's eyes and have them purchase, you know, a business unit under consent agreement, and then they get out of it. You also have paragraph 6 and 7 here, which is ensure adequate staffing for ITAR compliance with clearly defined lines of authority and career paths and internal review of ITAR compliance resources. So from a TC resources perspective, you have to ensure adequate resources are dedicated to compliance, establish policies and procedures governing those TC resources and their activities, ensure lines of authority, performance evaluations, and career paths. So you have to take it seriously, and there has to be a professional path for advancement for your trade compliance personnel. Then you have to conduct a resource study. So within 120 days, respondent and the designated official shall conduct a review and establish an action plan for addressing resource issues. And this is really where you get into risk, resource, and workload management, right? So you have to identify your resources, but in order to determine whether or not they're adequate, you have to determine what the workload is, right? You have to see if they're working on the things that are your risks. So typically the way the companies will approach this is they'll conduct a time study to see, you know, what their people are doing, what transactions they're processing, what problems they're working to solve, projects, etc., in order to determine how their folks are spending their time. Next, we'll cover paragraphs 8, 9, and 11. 8 essentially established the DO requirement, so that appointment has to come within 60 days, so we should be seeing that fairly soon. It defines their areas of responsibility, which includes specific duties such as oversight of remedial measures and expenditures and incorporation in the business plans at the senior executive level, so ensuring that senior executive engagement. Reporting, so tracking of violations. There's a 6-month status reports that are due for the entire term of the consent agreement, which includes accounting for expenditures. And then they're responsible for policies and procedures. So let's take a quick look at that, because this is really kind of a prescriptive set of requirements that you have to implement from a consent agreement perspective. So as described in paragraph 8, you have staffing requirements, you have integration and business planning, you have supplier vetting, so knowing who you're doing business with, you have identity management, knowing who your people are, you have restricted party screening, so screening of your business partners and your people, you have the identification and classification of defense articles and services, and the steps and the identification and classification of technical data. You have export authorization management, including scopes, terms, conditions, provisos, and temporary exports. And I put part 130 in that because in my mind, it's really a license reporting requirement. You have maintenance and protection of and access to technical data on computer networks and other electronic methods of storage and transfer. So this is an actual policy and procedure requirement that the company has to implement. And then you get into physical security controls, shipping controls, record keeping, and then finally the ability to detect, prevent, and report corrective action or report violations. Paragraph 9, strength compliance program. So within 12 months, the company has to have instituted strengthened corporate compliance procedures. They have to train people on that, including all employees engaged in ITAR-related activities, all personnel responsible for supervising these employees, including managers and business units, training records, who, what, when, where, and how. And this requires the company to implement paragraph 8 policies and procedures. That's essentially what paragraph 11 says, is, hey, implement the policies and procedures that are called out in the the designated official section. Self-assessment of functional processes. So that perform an internal assessment of functional process to evaluate compliance. This is conducted under a review of a functional process expert who's independent of trade compliance. So the Department of State saying there has to be a self-assessment, and your business folks have to own it, right? They have to own compliance within their function. The plan due, DUE, the plan is due within 60 days of the date of the order. And really, when you're going out and you're doing a self-assessment function, you have to identify what your functions are, right? You have to identify what processes you care about within those functions. You have to identify what IT systems you care about within those functions. So these are the support and management functions. You have to do the same thing from an operational function and process perspective. This is a type of framework that you need in order to execute not only self-assessment, but really any type of program that's going to go out and mitigate your risk. You have to know these things. You have the paragraph 12, which is requirement for comprehensive automated export compliance system, and we're just about through here. So the comprehensive automated export compliance system requires you to strengthen internal. The purpose of it is to strengthen internal controls and enhance oversight. One of the requirements is to track the decision process from the initiation to conclusion of request for export, re-export, retransfer. You have the initial identification of technical data and technical systems proposed to be disclosed to any foreign persons. A means of alerting users of ITAR requirements and electronic transmissions of controlled data, so notifications, for example, in email systems. And training to all employees to ensure all technical data exports are authorized in accordance with compliance policies and procedures. From an automated system perspective, there is no silver bullet. You have to take a systems approach, and it has to address these aspects: business partner management, who are you doing business with; identity management, who are your people; restricted party screening, are any of them bad actors; jurisdiction classification and marking. What are the items that you're exporting or that you're producing or that you're handling from both a raw material, hardware, software, information, and services perspective? All those elements that we just described come into your export authorization management. If FLIR wants to avoid the issues that they face with omissions, right, they have to be able to do these things that I've described in order to create export authorizations that address the full scope of their business transactions. And finally, once you have your export authorizations, you move to export transaction management. So these are actual controls of your visitors, your travel, your shipments, tech data transfers, and access controls. And finally, you need incident management, corrective action capabilities, and you need business intelligence. I can tell you how many companies that have automated or put in place controls where they can get access to information, and then they have no way of viewing into that information, right? No reports to review, or they have the reports and nobody's looking at them. No one's monitoring them and reacting. All right. So I believe there is the stopping point. There's some additional slides, but we're going to save those for the next series in the presentation, which I don't believe we mentioned at the first of the call that this was the first series. So there will be more to come on actually how to go out and mitigate these risks, both from a export compliance system perspective and a technical implementation perspective.
Great. So just to expand on what Matt said, this webinar we've gone through the consent agreement itself for FLIR, and we've alluded to a lot of things that need to happen. There's a lot about export control frameworks, a lot about IT systems, log management, identity management, business partner management. There's all these different areas that really have to be addressed for you to be able to properly manage and have an export control system that will meet the standards that the DDTC wants to see. And so we are going to have additional webinars following this up in the next couple months where we're going to dive into some of those requirements and some of those needs. Matt's going to continue to join us for those webinars. As we get into that, we'll start talking process, we'll start talking technical, and getting into systems that can actually help you achieve some of these goals. So Matt, we have a couple questions here I'm going to throw out there and let you take a shot at, and we'll see what else comes in. Okay. One gentleman asked, one comment made by DDTC regarding the contribution of FLIR's management system. Is that in regard to decentralized operations?
It's a great question, and I'm not sure the exact comment the person's asking about within the charging letter consent agreement. But what you typically see is from a management perspective, if you have weak corporate governance, very little oversight, few resources, at the corporate level, policy, processes, procedures, and a general lack of knowledge and commitment at the corporate level, essentially the Department of State is going to force you to centralize that. And from a management perspective, include export compliance requirements in the business plans, in the strategy, in the gated process for pursuits review, right? To make sure that export compliance is integrated into that management system. So, not sure if that answered the question, but we can certainly take a follow-up here in a minute.
Great. And I have another question here, and I'll take part of this, and you can take part of it, Matt. The question is basically about small business, and the IT systems, the process and policy systems that need to be in place to manage things like DFARS compliance and ITAR compliance and NIST 800-171 compliance. These are all relatively high-cost systems, processes, policies, procedures that have to be in place to manage all these different compliance requirements. What do you recommend, Matt, for convincing upper management that these are things that have to take place? They're not optional, and if you want to do business in this market, you have to have it.
Yeah, Scott, it's a great question, and it kind of goes to some of the slides that we're going to we didn't get to today, but that we'll lead in with the next presentation. It really takes a shift in the mindset and the approach of export compliance. And traditionally, the way that compliance folks have approached export compliance is to prevent unauthorized exports by preventing all exports. So what I mean is, by default, the answer is no, right? And you become a barrier to business. Companies want to go out and they want to get embedded, Indian national engineers within their programs, right? The answer is no, because you can't enable authorized access, right? And so the shift in the mindset you have to take is, we're going to enable authorized business, right? We take these approaches, we be proactive and invest in export compliance. We're going to know what our data is. We're going to know who our people are, and we're going to be able to enable about 80% of the exports that need to occur within our environment automatically.
So
go to market faster, use cheaper sources of inputs, whether you're purchasing stuff internationally or whether you're using, like I say, low-cost engineers.
So Matt, take for instance a 50-user defense contractor that has ITAR data. They want to put in a comprehensive, compliant ITAR export control solution. Mm-hmm. What kind of dollars are you talking about to put a solution like that in place?
Well, it really just depends. If you're a 50-person company, you can certainly get to low-cost solutions in using SharePoint and Flow and some of the functionality that's available in Office 365 or in those on-premise solutions. It's fairly easy to create forms, workflows, reports to help you manage those transactions and get visibility into them. And I certainly think that is an excellent option. And I think those low-cost options are actually the wave of the future, as far as going out and addressing some of the automation needs that you have within the company.
Great, thanks. So another question, a follow-up really to that one, is how long does it typically for a company to establish a comprehensive automated export control system?
It's absolutely a journey, and it really depends on where you're starting from. The reason you want to stay out from under consent agreement is if you enter a consent agreement, you have to boil the ocean, you have to do a bunch of non-value added activity, and there's not necessarily any rhyme or reason to the order in which you approach that. So you certainly want to evaluate where you're at. You want to look at identity management, jurisdiction classification, export authorization management, all those capabilities that we spoke of earlier, and essentially establish a roadmap, all right? And you're not going to jump immediately to enabling authorized exports in SharePoint, for example, when you don't know, you have no capabilities to manage identities. You don't have capabilities to identify export control data in your IT network. So you certainly want to develop that roadmap that builds those foundational capabilities so that you have the information that you need to make accurate autonomy export control decisions downstream. So